mheshimiwa.
Habari ya leo. Kwa majina naitwa Isoe. Mimi ni wakili wa Bwana David Lemayian Angoye. Ningependa kuuliza maswali kadhaa. Ni sawa? Kwa statement yako umetueleza kwa kina matukio ya tarehe 12 mwezi wa Agosti mwaka 2022. Kuanzia asubuhi vile mliamka. Umetupia kwa kina habari hiyo. Kweli? Nimepitia statement zako, uliandika mbili. Moja uliandika tarehe 13 mwezi wa 8 mwaka 2012 ambayo kwa kina umetueleza matukio, alafu ya pili ambayo uliandika tarehe 16 mwezi wa 10 mwaka 2020. Yes.
How long are you likely to take in your course?
I have very few questions here.
How many?
Let's say, depending on how he answers, 10 minutes.
10.
Yes. Depending on. Yeah. Yes, thank you. Nilikuwa nimesema uliandika taarifa mbili. Tarehe 13 mwezi wa 8 mwaka 2022, tarehe 16 mwezi wa 10 mwaka 2022. Kweli? Sawa. Nimepitia hizo taarifa zote mbili na hakuna mahali popote nimeona ukisema kwamba ulikuwa na shauku na Bwana David kuhusika na kitendo cha unajisi na kifo cha mwanao. Ni kweli?
Ni kweli, lakini kwa nini nimekuambia kuna mwenye atatoa hiyo testimony.
Nasema wewe ni sawa. Huyu atakuja. Wewe kwa taarifa zako mbili. Nataka tukubaliane kwamba nakuuliza maswali kulingana na taarifa yako hii na ambayo umepeana koti leo asubuhi. Sawa sawa? Na tarehe 16 mwezi wa 10 hakuna mahali popote umesema ulikuwa na shauku ama ulikuwa na, kwa kimombo nasema suspicion, kwamba Bwana David alikuwa shauku kwamba Bwana David alikuwa amehusika na kitendo cha unyama ambacho kilitendeka. Ni kweli? Asante. Nataka uzibu. Kwa taarifa yako ya leo umetuambia kwamba tarehe 12 mwezi Agosti mwaka wa 2022 ulikutana na David masaa ya jioni.
Akiingia kwake?
Umesema hivyo? Lakini nataka kupeleka kwa taarifa yako tarehe 16 mwezi wa 10. Hivi ndio ulisema. Na nukuu kwa kimombo kwa sababu hivyo ndio imeandikwa hapa. On 12th August 2022, actually imeandikwa on 12th August 2922, my child, namely Vivian Bisiereri, went missing during the day and I tried looking for her without success. And the time I was going around looking for her, I did not see David Lemayian Angoye around. Even on 13th August 2022, I did not see him around until on 25th August 2022. Okay, Swahili. Nasema hapa kwamba tarehe 12 mwezi Agosti na tarehe 13 mwezi Agosti haukumuona David. Ulikuja kukutana na David tarehe 25 mwezi wa 8 mwaka 2012. Haya ambayo uliandika hapa na ambayo umesema leo hayaambatani. Ni gani kweli? Umetuambia hapa ukiulizwa na kiongozi wa mashtaka kwamba uliona David tarehe 12 jioni akiingia kwake, ulikuwa umetoka kurudi kutafuta mwanao, lakini kwa habari yako tarehe 16 mwezi wa 10 unasema haukuona David tarehe 12 wala hukumwona tarehe 13, ulimwona tarehe 25.
David nilimwona tarehe 12 usiku.
Hiyo ndio umesema, lakini taarifa yako ya tarehe 16 inasema vingine.
I saw David on what date umesema leo?
August
2022.
Lakini hiyo yambatani na taarifa yako ya tarehe 16 mwezi wa 10 mwaka wa 2022, kwa sababu kwa hii taarifa ambayo ni further statement kwa ile ya kwanza unasema ulimuona tarehe 25.
Hiyo statement ni ya date gani?
16th October 2022. Your Lordship.
October 2022.
The third paragraph
States what?
States that on 12th August 2022, my child, namely Vivian Bisiereri, went missing during the day, and I tried looking for her without success. And the time I was going round looking for her. I did not see David Lemayian Angoye around. And even on 13th August 2022, I did not see him around until on 25th August 2022, when I heard that David Lemayian Angoye had been arrested for the offense of assaulting a certain child within the area. That is paragraph 3 of the statement dated 16th October 2022, the further statement of Mr. Duncan Omwenga Oteri. Bwana Omwenga.
Yes,
So put the question.
Yes.
Did you see
So did you see, sasa nataka utuambie kulingana na taarifa yako ya leo. Ulimuona Bwana David Lemayian Angoye tarehe 12 Agosti 22?
Hiyo tarehe 12 mheshimiwa nilimuona.
Ulimuona?
Kioni kabisa.
Ulimuona?
Ingia kwake.
Kama ulimuona hivyo inamaanisha kwamba statement yako ya tarehe 16 mwezi wa 10 mwaka 2022 ni ya uongo. Kwa sababu hapa unasema ulimuona tarehe 25.
Nilimuona lakini pateni siku anajua kama yeye amefanya nini.
Sawa, kama unasema unataka uambie kwa ulimuona tarehe 12 ama tarehe 25. Ni tarehe moja uchague.
Hiyo tarehe 12 nilimuona.
Sawa. Sasa mimi nakueleza kwamba kuna habari yako ya taarifa yako tarehe 16 mwezi wa 10 22 ni ya uongo kulingana na vile umesema. Tuendelee na swali lingine. Umeambia hii koti kwamba ulipata taarifa kwamba Bwana David Lemayian alikuwa ameshikwa kwa kitendo cha assault kwa mtoto mwingine. Ulipata taarifa kutoka kwa mwanamke mwingine kutoka jirani yenu hapo. Sasa kwa kifupi ni taarifa yako katika hii koti asubuhi ya leo kwamba adhuhuri ya leo kwamba haukuwa na shauku yoyote kabla ya kuelezwa kwamba alikuwa ameshikwa, kwamba alikuwa amehusika katika kitendo hiki cha unyama kwa mtoto wako. Kabla hujaambiwa au kuwa na shauku yoyote.
Mheshimiwa hapo siku anajua.
Sawa. Anataka pia ueleze hii koti kwamba kwa ule muda ambao ulikuwa umemjua Bwana David hamkuwa na tofauti zozote kati yenu ama hamkuwa mmekosana kwa njia yote ama ile. Ni kweli?
Ni kweli.
Yale ambayo umeeleza hii koti ni kwamba baada ya kujulishwa ndipo ulikuja Kayole kuandikisha taarifa yako kuhusiana na hii kesi baada ya kushikwa na mambo mengine ambayo ulikuja kuelezwa baadaye. Ni kweli? Bwana Omwenga.
Hello.
Una habari kwamba Bwana David na mkeo walikuwa wamejuana kutoka mwaka wa 2020? Huyu na mkeo walikuwa wamejuana kuanzia huyu Bwana David na mke wake. Walikuwa wamejuana.
Did you know?
Did you know? Okay. Did you know that Mr. David Lemayian Angoye had a relationship with your wife from the year 2010?
Which kind of relationship?
Sexual relationship. Did you know?
Maybe my wife will testify.
No, I'm just asking. That is for you.
I mean, that one I don't know.
It is either yes or no.
No.
You do not know.
I mean, it don't know.
Just a minute, counsel.
Yes, yeah.
Since when?
2010. So, did you equally know that they knew each other? That is from 2010.
Yeah, I don't know.
You don't know.
Since 2010.
Did you equally know that that relationship that Mr. David and your wife had been rekindled 7 months prior to the events that occurred, the unfortunate events that occurred?
I don't know.
You don't know.
Yeah.
Rekindle basically ni kusema waliuanzisha tena kwa sababu walikuwa wamejuana wakaachana alafu wakakutana tena miezi 7 kabla ya kitendo hiko.
7 months.
Yes.
7 months. Your instructions, the relationship had died.
He was not clear, but he said the relationship died sometime after a period of 9 years. Somewhere there, he was not clear. But it was rekindled when he moved to the premises. Yeah.
It's important we need to come to this.
Yes.
Died 9 years after 2010.
Yes. That is according to my client. Did you equally know that they continued their sexual escapades within the plot after Mr. David Lemayian moved to that ground floor house?
I don't know.
Yes, counsel.
Your Lordship, on behalf of the victim, and having consulted with
Yes.
counsel for the prosecution, we wish to object to that line of cross-examination, but the same is not relevant to the current proceedings.
This is not what?
It's irrelevant to the proceedings at bar, Your Lordship.
Proceedings. Because these are not divorce proceedings.
That's correct, Your Lordship. This court should not allow counsel to descend to that arena. Because doing so would prejudice it's not the wish of the victim, family, Your Lordship. For the others, good relationship enjoyed between the parents of the deceased to be paraded before this court. We'll be praying that the court guides counsel to move to more important questions or better skill, sit down for the next witness. The most obliged.
Me, Your Lordship.
What is your answer?
My answer first, yes.
What relevance?
Yeah, the relevance is you will have noticed that when you are cross-examining the government chemist, I had a very clear line of questioning in terms of mixing of clothes and everything else.
So the basis,
The basis of my defense theory is very clear in terms of,
you'd rather say it
Yeah.
so that we are able to
Yeah.
determine relevance.
and that's the reason why I had sought for,
Basis of the line
yes,
of questioning
emanates from
emanates from
the initial line of cross-examination.
my instruction.
Yes, from my instruction first from my client, and
From my client.
yes, having informed me of this new development during our pre-trial engagements, and subsequently my line of questioning when I was cross-examining the government chemist.
So that what is your case theory?
My case theory is very simple. That the evidence of seminal fluids in the kids' clothes were not as a result of interactions between David and the victim, but as a consequence of the mixture of the clothes between that belonged to the spouse and the kids during washing.
Just a minute. So, the theory you propose is that
The origin of the seminal fluids.
the presence
Yes.
of seminal fluids in the clothes of the child,
Yes.
in the clothes of the deceased,
Yeah.
was
Emanated from the mixing of the laundries belonging to the spouse of the witness on the stand.
of laundry belonging to the spouse
Of PW2.
of PW2.
Yeah.
If I may,
Just a minute, counsel.
Yeah.
These are very
Yeah.
critical issues because that line of defense, if that is the line they're taking, let's see how far this goes. So, laundry belonging to the spouse of PW2.
And during laundry washing and with the laundry clothes of the deceased.
Sorry, the theory we propound is that the presence of seminal fluids in the clothes of the deceased was from the mixing of laundry belonging to the spouse of PW2
Yeah.
and those of the deceased.
Yes.
But not, you are saying, but not a direct contact between him and the victim.
Yes, as alleged in the.
As a result, contact between the accused and the deceased victim.
Yes, yeah. Yes, Your Lordship. So the claims, and this is very unfortunate coming from my co-counsel.
Yeah.
In cross-examination, we are allowed to go quite length. I had a basis. Yes.
Pursue your defense.
Yes,
It
I
is-
had a
it
basis
is
for.
about-
Yeah.
It is about your client's liberty and his life
Yes.
against the testimony of the witness.
Yes, Your Lordship. So the claim that I'm going through a rabbit hole is a bit unfair and unfair.
So that is the basis
Yes.
of your prosecution.
Yes. Yes.
Okay.
If they are able to demystify my theory, well and good.
Are you able to react to that? On relevance? Because that is the line is drawing before I rule. Any reaction?
Yes.
Yes.
when you asked my colleague the relevance of the evidence intents or the relevance of the questions that he was posing to the witness,
Yes.
and was making reference to a defense theory, it was not upon him then to argue the defense case at this stage.
The thing is this, if I understood what he said, he had already laid a basis through the government analyst that there is a possibility DNA material could move from one cloth to another should there be a mix in washing. And then he is developing it further through your witness to say, your wife and my client had a sexual relationship, and as a result of the clothes being washed together, DNA may have moved over. Have I gotten it right?
Yes.
Is that the argument you're making?
Yes, Your Lordship.
So that then for him he says the question is posing is relevant to that extent. That's why I'm asking. Now, given the basis he has laid, what do you say? Do you still maintain that the question is irrelevant?
Your Lordship, I still maintain that the question is relevant and wait upon the court's ruling.
Okay.
Your Lordship, just as a rejoinder.
No.
Sorry.
take a break of 20 minutes. 2:15, huh?
Most obliged.
Questions that touch on their marriage. In the course of cross-examination, counsel for the accused alluded to sexual interactions between his client and the wife of PW2. The defense counsel has informed the court that the instructions that he has are that the accused person and the mother of the deceased had a sexual relationship, and as a result, it is possible that the DNA profiles of the accused person could have been transferred to the clothes of the deceased during washing of clothes, if at all the deceased clothes may have been mixed with those of the mother. That is the theory the defense is advancing, and the theory was started by being developed during the testimony of PW1, the government analyst, who testified to the possibility of transfer of DNA profiles in the course of washing of garments. Mr. Anyona, counsel for the victims, has opposed the line of cross-examination, raising the issue of relevance, and that in his view, the defense counsel is bent on causing a rift in an otherwise quiet marriage. The victims' counsel urged the court to restrain counsel for the accused and order him to abandon that line of cross-examination. This court has heard both counsel, and I hereby note that the issue at the core of the trial will be how one can possibly explain the presence of semen in the clothes of the deceased that has DNA profiles of the accused, without inferring that the accused had sexual intercourse with the deceased and that he deposited his semen on her clothes. The defense, to dislodge such an adverse inference, is alluding to the fact that the mother of the deceased had sexual intercourse with the accused, and that through that interaction, the accused's DNA could have found its presence on the clothes of the deceased, if at all the mother washed her clothes together with those of the deceased. The defense counsel has thus argued that the questioning he has adopted is relevant to the issues under consideration. It is important for the court to clarify that the right to cross-examination of a witness is underpinned under Article 50 of the Constitution, and it is important for an accused, for an accused to be permitted without a necessary fetter where such cross-examination is geared towards establishing the existence or non-existence of a fact material to the proceeding, to pose questions that he considers important for the defense. The court under Section 159 of the Evidence Act has the power to limit cross-examination where, in the opinion of the court, any questions or inquiries being made are indecent and scandalous. The court must, however, be cautious not to gag a party from raising questions in cross-examination that relate to facts in issue, and also that relate to the facts in issue or necessary matters to be known in order to determine whether or not the fact in issue existed. The fact in issue here is how did the DNA profile of the accused end up in the clothes of the deceased. The prosecution is mounting a theory to incriminate the accused and the accused on the other, and is presenting a factual matrix which in its view will help explain away the presence of the DNA on the clothes of the deceased. The issue is so central, in my view, to be ignored. The charge of murder is a very consequential one in terms of sentencing, and the accused person must be allowed to put across questions to witnesses that would help him explain away certain critical things that may, if not properly explained, lead the court to drawing an adverse inference against him. The question of an adulterous lifestyle of the accused has come into focus, and he wants to demonstrate how that adulterous lifestyle of his could have transferred his DNA profiles to the clothes of the deceased. The presence of DNA profiles on the clothes of the presence of the DNA profiles of the accused on the clothes of the deceased having been proved by PW1, the accused certainly has to be allowed to test that evidence, to test the prosecution witness's evidence in the best way he can to try and mount his defense. The witness on the stand is not being accused of anything by the accused. Thus, the questions as to whether he knew of any illicit sexual affair between his wife and the accused is not needlessly offensive. It is a matter he can competently deal with. The view of the court is that the matters being raised by the defense with PW2 are relevant in terms of Section 11B of the Evidence Act, for they may make the existence or non-existence of the fact of DNA profiles of the accused on the clothes of the deceased probable or improbable. The objection by counsel for the victim is that overruled, and the hearing shall proceed accordingly. The defense counsel is to proceed with the cross-examination, sticking to the issue of the accused's person's DNA profiles present on the deceased, on the clothes of the deceased, but should not ask questions that are calculated to annoy or embarrass PW2. It is so ordered. Yes. So let's focus on the DNA, because I think that is the issue that really is at the center of this. So, counsel, proceed. Let's see how we can conclude, at least if we can finish with this witness.
Yes, Your Lordship.
Yes.
Nitakuuliza maswali machache tu. Wakili alikuwa amekuuliza kuhusu kuona mshtakiwa tarehe 12 na pia ukaweza kusema kwamba ulimuona tarehe 12, lakini statement yako ilikuwa inasema haukumuona tarehe 12 na 13, ila ulimuona tarehe 25. Na swali langu ni, kuna sababu yoyote wewe ukiwa hapa mbele ya mahakama kudanganya hii mahakama kwamba ulimuona tarehe 12 jioni? Kuna sababu yote ya kudanganya hii mahakama kwamba ulimuona tarehe 12 na si 25?
Hiyo tarehe 12, mheshimiwa, nikiendelea kutafuta mtoto alinipita akaingia kwake.
On 12 tarehe 12 kwa mwezi wa
08.
Sorry, mwezi wa 8 2022. Unasema mshtakiwa alifanya nini?
Endelea, sema.
Nilimuona akipita akienda kwake. Lakini by then sikuwa najua kama yeye ndiye alikuwa amefanya hiyo kitendo.
Kwa hivyo ni ukweli wako kwamba wewe ulimuona tarehe 12. Okay. Kuna maswala ambayo unaweza kuulizwa kuhusu uhusiano wa mke wako na mshtakiwa, kwamba kama ulikuwa unajua kama wako na uhusiano wowote pale kutoka mwaka wa 2010. Unaweza tueleza kama mwaka wa 2010 wewe na mke wako mlikuwa pamoja?
Mheshimiwa, 2010 tulikuwa pamoja.
Mlioana mwaka gani?
2006.
2006, I got married. To the deceased.
Okay. Na kwa hiyo kutoka 2026 mpaka 2022.
Sorry, 2020?
Kutoka 2006, sorry. My apologies, I think I was still in primary. 2006 mpaka 2022. Uhusiano wenu ulikuwa kivipi?
Mheshimiwa, nikueleza ukweli. Yes. Mimi tangu hiyo wakati 2006.
Yes.
Mpaka now. Up to now.
Yes.
Sijawahi kukosana na bibi yangu.
Mjawahi kukosana na bibi yako. Na uko na jambo gani la kusema kuhusiana na hiyo mambo kwamba mshtakiwa anasema walikuwa na uhusiano na bibi yako? Kuna jambo gani la kusema?
Sina nyingine ya kuongeza.
Hauna.
Sina nyingine ya kuongeza kwa sababu hiyo kitu naona tu ni ya uongo.
The lie. You're saying the uongo.
Uongo kabisa.
My Lord, that